Thank you. Please be seated. Good morning. We're here for oral argument in the case of Steinmetz versus Everyone Wins. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the time you begin your argument. Each side will have 20 minutes. Appellant counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed this case at conference already. So with that, counsel, you may proceed.
Good morning, Your Honors. Paul Levine on behalf of Appellant Steinmetz. I'd like to reserve 5 minutes for my rebuttal. I appreciate the fact that the court has already reviewed the briefs. One item that I would like to point out with respect to the underlying facts, which is not controverted, is that the appellee, Everyone Wins, was not named as a defendant in the underlying HOA foreclosure complaint. And its predecessor, who was the holder or beneficiary of the first lien position. And that is because when the HOA filed its foreclosure complaint, the senior lien holder was not a necessary party because it held a senior lien, and because the HOA foreclosure complaint did not and would not prejudice the senior lien holder's position. And it was for that reason that Everyone Wins had to intervene in order to have a position to take when the surplus funds were at issue. But it is important to note that Everyone Wins was not a necessary party because its rights were not prejudiced. This was a foreclosure of an HOA lien on a residence of 2.5 acres or less. There's no question and no dispute that the senior position deed of trust was a purchase money deed of trust. The HOA obtained judgment against the only defendant, Steinmetz. It proceeded to foreclose, and a writ of special execution was issued. And I think that's something I would like to highlight, that it was a writ of special execution, not general execution, because the HOA judgment specifically identified the property to be foreclosed. We know that there was a related entity to Everyone Wins that was the successful purchaser and resulting in excess proceeds in excess of $31,000. Counsel,
you mentioned, or you started with the fact that Everyone Wins or its predecessor was not named in the original suit. Did the original holder of the deed of trust receive notice of the HOA's foreclosure action?
I am not aware. The court docket does not indicate that it was served, and it would have no reason to know. Now, whether...
Should they have?
No.
They should not have been served?
They did not need to be served because the HOA lien is junior to the senior position deed of trust. Junior.
Let me see, just so that I understand. So the holder, the primary lender of the property, holder of the deed of trust, has this property where the HOA forecloses and sells the property, and they don't have a right to know that?
They don't. Because...
So what happens to the funds owed to them?
They still maintain their position.
But they don't have anything to secure the loan.
Yes, they do.
What do they have?
They have their first position deed of trust, because the HOA lien, by statute, is junior to a first position purchase money loan. So just like an HOA can foreclose, so can a second or a third or a judgment creditor, and it does not impact or prejudice the rights of a senior position lien holder, in this case, a first position deed of trust. So to answer your question, did the senior have a right to receive notice? I mean, as a courtesy, maybe the HOA could have given notice, but there's no rule of law that says when a junior forecloses, it has to give notice to the senior because the rights aren't affected. They are not affected.
Let's cut to the chase. You are arguing the anti-deficiency statute, is that correct?
That's part of our argument, yes.
All right, let's talk about the anti-deficiency statute. What is the definition of deficiency?
A deficiency by the legal definition is post-foreclosure. In this case, post-foreclosure of the first position deed of trust. So let's just, in theory, say there's a $100,000 deed of trust, and the amount owed at time of the trustee's sale is $100,000.
Right.
If the property sells for 80,
Right.
there's a $20,000 deficiency.
Correct. So
That holder,
hold on. I know what a deficiency is.
Okay.
What I'm asking you is, why do you think a statute that says if we don't collect enough money to satisfy all of the purchase money mortgage funds, right? If we don't collect enough money, we're not going to go after the homeowner, the original borrower. And the reason that we have the anti-deficiency statute, I think, is clear, is that we don't want to, in a foreclosure setting, put that homeowner in a position that they can never climb out of. That's what the anti-deficiency statute was adopted for, correct?
that's part of the public policy, yes.
Okay, so your client purchased a home and borrowed money to purchase the home.
Yes.
Okay. So your client has some interest in this home. We don't really know what it is. How much money in equity do you think your client had?
I have no,
Okay.
I don't know.
So explain this to me. Your client has purchased this home. You have 35, let's just say you have $10 that you borrowed, because I'm a lawyer because I would love to be a doctor, can't do math. We have $10 in this home. At $10, we have borrowed $8, right?
Okay.
Okay. So the mortgagor has the money and the interest. Okay? So let's just call it everyone wins. Has the money, has the interest in the home. Your client gets the money, purchases the home. Everything is involved in that home. Would you agree?
I'm not sure what you mean by everything is involved.
I mean, everyone wins interest is the first position on the house.
Correct.
Okay, your client's position is that he owes everyone wins.
Correct.
And everyone's equity or value is involved in the home.
You mean everyone wins?
I mean, everyone involved in the transaction.
Okay.
That's a bit confusing.
Yeah, I'm sorry.
Okay. So, HOA forecloses. They get paid.
Yes.
Where's your client's skin in this game if everyone wins and their predecessor in interest put up all the money to purchase the house?
Well, first of all, I don't know what at the time of purchase, I don't know how much money Steinmetz put to buy the property over and above the loan. So that will be lost.
Okay.
That's going to be lost.
Their equity is gone.
Their equity is gone. And I didn't write the statutes. You can,
I just want to logically understand your argument, and I'm really struggling to
Okay.
do that. So that's what I'm giving you the
Okay.
opportunity. Help me help you.
Okay, so I guess the way I would respond is there's a legislative and a public policy that says that everyone wins. Their only recourse is the property. That's what the law says. So in this particular case, when the HO, and by the way, we know that the sister company of Everyone Wins made a mistake at the sale, and that's why they bid what they bid. Nobody disputes that. But the point is that if you permit Everyone Wins to get the excess proceeds, they're getting something that the statute would not permit them to have, because they still have, remember, they still have their first position security interest, so they can still foreclose. And if they were to foreclose, the only thing they would get is the physical, real property. But when the trial court gave them money, $31,000, the effect of that, nobody can challenge this, is they got Everyone Wins, received $31,000 more than their remedy by law. Their remedy by law is to foreclose on the property only.
And if we put all of that aside and we stand in the shoes of your client borrowed money to buy a house. The HOA, he didn't pay. So they foreclose. And why do you believe that you can read the anti-deficiency statute to justify giving your client a windfall of proceeds that he never put into that house?
Well, first of all, property values increase.
True.
There were literally thousands and thousands of cases where there was a foreclosure over the last 10 years where the owner lost the property, didn't make payments, defaulted on a loan, and got excess proceeds.
And in those circumstances, the excess proceeds by definition means I knock out each of the lien holders. I pay what's owing on the house, and whatever's over what's owing goes to the client, because that's the equity that they earned. You remember my first question to you was, what kind of equity do you think your client had in this house?
Well,
I thought that was an interesting kind of issue, and you don't know. So,
okay, first of all, I understand what you just said about historical, if the first position loan forecloses, the excess proceeds after payment of the juniors goes to the owner. But there were, I don't know what the study is, but I'm very confident that there were many second position loans that foreclosed where the excess proceeds went to the owner. The issue, first of all, the issue of what my client had in the property is not, with all due respect, it was never part of the underlying record, and I'm not convinced that it's relevant here. I respect your question. But I think the underlying loan was $38,500, I think.
and we have that in the
And
record.
I don't know, public records would say what was paid for the price. For example, if the price was $50,000, he had $12,000 in the property. He would have lost everything but for the mistake of the third-party purchaser.
So let me see if I get you, if I'm following your argument, because I really would like to understand what you're saying. Your position is, if a property is sold in a special, by writ of special execution, that we pay the junior that foreclosed, we pay everybody flowing downhill from the junior, but we don't pay the senior, and that mortgage travels with the property. That's your argument.
That's my argument, and that's a statement of the law.
And your client should receive any excess after the juniors are wiped out.
Yes, because that's what the law says. Now, I want to respond a little bit to the point about the reliance on the statute, which is 33-727B as in boy. I think it's important to note that the argument of everyone wins is that the statute says that you should pay other liens on the property because you're foreclosing an HOA lien just like you would foreclose on a mortgage. But again, if we were foreclosing a second position mortgage, that first position lien holder would not be a party to the action because they're not necessary and their rights are not being prejudiced. So when you talk about other lien holders, you're talking about other lien holders who were named in the underlying foreclosure complaint. That's what the statute intended. And I want to point out something to the court. There was a reference to the second Nussbauer case, Imperial Yuma. This is the 1974 case. And I cited this case in my brief. It said, we hold that the court had jurisdiction to conduct a post-judgment proceeding in the nature of an accounting to determine whether or not there were surplus funds and who to pay them to. And then the court went on to say that under our statutes, the trial court, it cited 33-727B. Now, in this case, they applied the excess proceeds to the owner. So my point is that even in this case, the court understood that there was a senior that wanted money and said, you're not entitled to the money. You are not entitled to the money because you were never, in our case, the senior was never a party to the action. And again, I'm obviously trying to emphasize the point that the senior's rights were not prejudiced. And the law says, under the anti-deficiency statute, that you, the senior lien holder, your only recourse is the property. So logically, what the trial court did is say, you have your deed of trust. You can still foreclose on this property. And we don't know if you want to ask equity, I don't know. I don't think it matters, but it could be worth $110,000, $150,000 today. Plus you get $31,000. So the trial court is giving that senior, in this case, everyone wins, a windfall, something that by law it is not entitled to per the anti-deficiency statute. I'm running close to my 5.
Okay, the flaw I'm seeing here, and I just want to make sure I'm with you.
Sure.
Okay, so everyone wins. Let's say it's before they make the assignment to Jarvis. There's
Right.
that whole thing, but let's
Okay.
just talk about it conceptually. So the senior lien holder gets the property plus the loan is what you just said. The senior gets attachment to the property, the owner gets the property, and the proceeds.
Well, right now, after the sale, Jarvis owns the dirt, owns the property,
Right.
which is a sister company. So Steinmetz is out. He doesn't own anything.
Right.
So Jarvis owns the property subject to a first.
Right.
Everyone wins, has the right to foreclose if there's a default, in which case they get back the condo. I think that's what it is.
Okay.
And then they got a condo worth X. I don't know what it's worth today, probably worth more than what it was purchased for. But in any event, they get the condo, but by virtue of the trial court order, they also have $31,000. That's giving the senior lien holder, because remember, everyone wins, got $31,000. So now they have a deed of trust, first position, purchase money, secured loan, plus 31. That's giving everyone wins something they are not entitled to, not because I say it, but because of the statutes under the mortgage foreclosure statutes and the deed of trust foreclosure statutes.
Wait a minute, but just one point there. So under your scenario, when the HOA forecloses, everyone wins, has the condo.
Well, Jarvis owns the condo.
Well, Jarvis owns the condo, but everyone wins has the
First
loan,
position,
the first
yes.
position, the senior position mortgage holder. And so you're saying they have the land itself, and then they have this additional amount. But this additional amount reduces the debt
No.
owed, correct?
It probably does, yes.
Well, I mean, it does. I mean,
Okay.
if 100,000 was owed, and they have a deed of trust, and 100,000 is owed, now they get 30,000, and they don't have the property plus 30,000. They have 70,000 owed, secured by the property.
Right.
And whenever that 70,000 is paid off, they no longer have the property.
Right. But if they do foreclose, and they are the successful purchaser, they're going to own the property. And by virtue of this windfall, they got $31,000.
Well, but isn't that the same when a person gets the mortgage, pays on it, and they're so close, and they're $10,000 from paying off the house, but everyone loses their job, people die, and foreclosure, they get the house. I mean, nobody gets their money that they've paid in up until that last $10,000.
But that's not a true analogy, with all due respect.
Well, I think it is, because you're saying that once
If that, under your scenario, if the mortgage was paid down really low and it went to sale,
right.
if the mortgage holder is the successful purchaser, they get the property. If there's competitive bidding and it bids it up, and so there's excess proceeds, it will go to the next in line. And if there are no junior lien holders, to the owner of the property.
I was referring to the money that's already been paid.
Right, and that will pay down the mortgage. I don't dispute that.
Okay.
But the mortgage is still there. It's
All
never
right.
been released.
Do you want to reserve?
Please.
All right, thank you.
Good morning, if you may please the court. I'm Dan Kloberdance, represent the appellee, Everyone Wins LLC. Let me try to go in no particular order. I want to address a few things that Mr. Levine stated. First of all, procedurally, Mr. Levine is correct that the first lien holder, in this case, is not named in the judicial foreclosure. However, there's no excess proceeds at that time. Excess proceeds don't even exist until there's a sheriff's sale and a third party comes in and bids more than, in this case, the Homeowner Association's judgment, which is exactly what happened in this case. So procedurally, there's no excess proceeds when this judicial foreclosure is filed by the Homeowner Association. That's created after and upon the sheriff's sale, and then the sheriff deposits that money with the court. Now there's excess proceeds that become an issue in this case, and a third party would have to intervene if they're making a claim towards those excess proceeds. And the court's going to hear evidence and look at the law and disperse the funds according to the law. I want to point out, and I think the court, from the question, understands the irony. I'll call it the irony of Steinmetz coming in and asserting the anti-deficiency statutes, the same statutes that protect him from being sued on the note, protect him from any deficiency if his lenders foreclose. He's claiming that prevents his secured lender from making a claim for excess proceeds based on their collateral. The case law, there's a lot of case law anti-deficiency statutes in the public policy. And one reoccurring theme, and most notably in Helvetica versus Pasquan, the first Helvetica case, the court talks about the purpose of the public policies behind the anti-deficiency statute, and that is to prevent a creditor from going after other assets of the debtor when the debtor loses his or her house at a foreclosure. And the courts say that the secured creditor must look to its collateral only. It's exactly what happened here. The first lien holder has a deed of trust. The collateral is the deed of trust against the property. We're not going after other assets of Steinmetz. We're not garnishing a bank account. We're not suing him on the note. We're not suing him for deficiency. Rather, what Everyone Wins is doing here is they're making a claim based on its collateral, based on its lien. If anything, the public policy of the anti-deficiency statute is clearly on the side of Everyone Wins because we're making a claim. This is like the expansion of the anti-deficiency statute the appellant's arguing. Let's say the house burns down, and normally all mortgages, deed of trust have a clause, the lender's entitled to insurance proceeds. Steinmetz comes in and argues, anti-deficiency statutes protect me. You can't get proceeds from your own collateral. And I'm allowed to keep all the proceeds from the insurance company based on the anti-deficiency statutes. That's not exactly what Mr. Levine is arguing, but it's very close. And again, I consider it very ironic that he's asserting the anti-deficiency statutes, the same set of statutes that protect him against any action, from a first lien holder collecting those excess proceeds. What I thought was the central issue of this case, which the appellant hasn't really argued a whole lot, is the statutes, the deed of trust.
To be fair, we've not given him too much of an opportunity.
Oh, you haven't, but I'm actually referring to his reply brief. He's concentrated on the deed of trust. No, he certainly hasn't abandoned that argument. But he's asking this court to rewrite the judicial foreclosure statute, specifically 3327B, which I think is very, very clear. And it doesn't say anything about only junior lien holders. It says other liens. Other liens will be paid in their order. The statute, again, 727B, is crystal clear. It's the complete opposite of the deed of trust excess proceeds statute, which clearly does not apply here, which limits recovery to junior lien holders for excess proceeds. There are, and I talk about this in my answering brief about why the legislative might have seen a difference. It's always dangerous when you try to guess legislative intent because these things are done in piecemeal. You've got one law enacted in 1971, you got another one in 1985, and they don't flow necessarily like you would like them to. But what's certain here is we've got a deed of trust excess proceeds statute that's limited to recovery by junior lien holders, junior to the foreclosing creditor. We've got a judicial foreclosure statute that doesn't limit to junior. It says other liens shall be paid in their order. Here, Everyone Wins acquired, I'm going to be blunt, Everyone Wins acquired this first position deed of trust, paid full price for it because of what the statute says. because the statutes were so clear that in a judicial foreclosure, which is a homeowner association lawsuit, like we have here, that the first lien holder is entitled to those excess proceeds.
Can you address Mr. Levine's issue, writ of special versus general execution, and what he believes the issue in the statute is?
I'm not sure I understand his. I understand his anti-deficiency argument. I don't know. I don't understand the difference between a general writ of execution, a special. Special obviously applies to a specific piece of property, but here there's everyone wins is not performing any kind of execution on its lien. We're not taking any action. We're just stepping in saying, hey, court, we have a first position deed of trust that has priority. We are the only lien holder on this property, and there's excess proceeds. So it's not even an action. In fact, Long versus Corbett, and that's a case I've cited in my answering brief, where this court, it's a 1995 opinion, this court specifically held that a secured creditor's receipt of excess proceeds was not an action by that secured creditor. And it's not exactly the same issue here, but it's darn close. In fact, I want to read one sentence from Long versus Corbett, because I think it conclusively decides this case, actually. Although Long, that's the secured creditor, although Long did receive the excess proceeds from the trustee sale, his receipt of what remained from someone else's trustee sale cannot reasonably be said to have been an election of remedies by him. Wow, that's precedent from this court saying if you obtain excess proceeds, that's not an action. In the anti-deficiency statutes, we're at issue in Long versus Corbett. The debtor was making a very similar argument to what the appellant's making in this particular case, that the anti-deficiency statutes apply to an action by another creditor where there's excess proceeds. The court said, no, that's not an action by the secured creditor, and therefore the secured creditor is allowed to continue on with this lien, doesn't lose its lien. So it was not the exact issue, but it's very, very, very similar.
When we look at, and it may be in the record, but I didn't see it. When we look at the sale, there was $30,000 and some odd dollars, and the original loan was 38 and some odd, I believe. So was the first position mortgage fully satisfied by the excess proceeds from the sale?
No. In fact, and this is in the record, it's in the one of the applications, motion to intervene, RA 47. Okay. And I cite this in my answer in brief in the factual background. And there, what I'm pointing out to the court, and I pointed out this to the trial court, and we talk about equities. There, the loan amount for the original first position loan, it was originally $38,250. It grew in a matter of a few years from $38,000 to $52,000 because Steinmetz never made a payment. He never paid his HOA, didn't pay his first mortgage, doesn't pay his taxes, doesn't pay anything, and this is a rental property. I mean, the record's not clear about how much rent he collected, but he doesn't put a penny into this, and now he's arguing he's entitled to his excess proceeds. He had the right to redeem. Why didn't Mr. Steinmetz redeem? And that's really why there's a difference between I think there's a difference between the two statutes, the deed of trust excess proceeds versus the judicial foreclosure proceeds, is because in a judicial foreclosure, like the one we have here, Steinmetz had the right to redeem. He had 6 months after the trustee sale to pay the purchaser at the sheriff's sale the money back plus 8%. He gets the property, and he would have the right, those excess proceeds, wherever they're applied, he's going to get the benefit of that. But he walks away from the property like he walked away from making his payments the day he bought the property. You want to talk about windfall? I mean, this is preventing a windfall.
And when we talk about that right to redeem, it's 6 months, and if, let's say, he did redeem and paid the 8% to the purchaser and received the property back, that property would have been subject to the first mortgage.
Correct.
Still.
Correct, it would. And it's still subject to the first mortgage, but reduced by the obviously, and I think we are all in agreement on this, the $31,000 that Everyone Wins receives, it has to be credited towards the loan. I mean, it's an accounting issue, but definitely it's got to be applied to the loan. So you don't get to keep the excess proceeds and claim the entire lien. That's not the case. So the redemption, in fact, I would think that if there was a lot of equity, you would expect to see Steinmetz redeem the property, but he didn't in this particular case, and I couldn't tell you why or why not he did that. I can only speculate. Going back to the deficiency, if you look at the definition under the judicial foreclosure anti-deficiency statute, and I agree that's the one that we should be looking at, 33729A. It states that if assuming the property qualifies under 2.5 acres, which this is, says such mortgage shall not extend to any other property of the judgment debtor, nor may general execution be issued against the judgment debtor to enforce such judgment. And it goes on to talk about if the mortgage property is sold and it's insufficient, you're not going to get a deficiency judgment. So the anti-deficiency statute on its own terms prevents the lender, in this case it would prevent Everyone Wins, who's now in first position, from going after other property of Steinmetz. And we look at the case law interpreting this and really expanding the statute to prevent lawsuits on the note, and the court says you've got to look to the collateral. That's your only remedy, and that's exactly what happened here. We're looking to the collateral. Pellett's argument is it just ignores the fact that this entire time we're talking about a first position lender that has collateral against this property. We're not coming in and executing on an asset. We're just asserting our lien position and saying we're entitled to these monies because we are a secured creditor. And you know what? The judicial foreclosure excess proceeds statutes says we are paid first.
And you agree with me that had Everyone Wins not, do you have a question? Okay. Had Everyone Wins not stepped in, the first position lien holder who originally fronted the money as a mortgage would still be owed whatever wasn't collected by the excess proceeds.
Yes.
And your client Jarvis, who owns the property, would still be on the hook to pay that first mortgage person back whatever was not paid, the amount between the 30 whatever they got from the excess proceeds up to the 52 less whatever that was owed on the property.
If I understand your question, I believe yes.
Baby, yes. Clear as mud. Sorry.
Okay. Yes. So I'm just trying to think if there's anything. I think I'll just leave this. I'm not going to use my 20 minutes because I have 20 minutes, but just leave you with this thought. I just want to read the beginning of 33-727B because it's so important in this case. If there are other liens on the property sold or other payments secured by the same mortgage, they shall be paid in their order. And then the statute says, and if there are no other liens, the balance should be paid to the mortgagor. Again, I don't think the statute could be more clear. We could argue that maybe that's not good policy under some circumstances. Some circumstances it is good policy. I think it's good policy in this particular case, particularly. But the statutes are very clear. And I want to just emphasize that Everyone Wins, the actions they took here in acquiring the original deed of trust were based on what the statutes already said. And for this court to go in and rewrite the statutes and widely expand the anti-deficiency statutes after my client has relied on what the statute says so clearly is just as this court knows, it's not this court's job to rewrite legislation, even if the court thinks it's maybe not the best public policy. But in this case, certainly Steinmetz is the equities don't work in his favor, and there's no reason to expand the anti-deficiency statutes. And I think even to do that would be a reversal of the Long versus Corbett case that this court's already decided. So if there's no other questions, or I'm happy to answer any questions.
No, thank you.
Okay, thank you very much.
I will try to make my comments succinct. the effect of this, of affirming the trial court's ruling would be far-reaching. It would allow the holder of a deed of trust, who has a second position deed of trust, who also holds the first, to
Well, they're different entities, though.
No. I'm talking about what would happen if the trial court's ruling is affirmed. Mm-hmm. Somebody could take this ruling and say, look, I hold the first and the second. I'm going to judicially foreclose the second. Mm-hmm. I know there's going to be excess. I'm going to take the chance there's excess proceeds. And then, because it's a judicial foreclosure, I'm going to seek the excess proceeds and apply it to the first. Second, the analogy about if the house burns down is not a true analogy, because there's protections in the deed of trust itself in the event of insurance proceeds or calamity to the property. We are not asking this court to rewrite 33727B. Again, I go back to the issue. There is a difference between an HOA, foreclosure of an HOA lien, and foreclosure of a mortgage. For example, a purchase money loan, there's no recourse against the borrower. In an HOA foreclosure, there is a recourse. If the HOA foreclosed and there wasn't enough money to pay the HOA everything it was due, it could still go after Steinmetz. Other distinctions.
Counsel, we're out of time now.
Thank you.
We thank you both for your arguments. This matter will now be taken under advisement. We will take a short break to prepare the courtroom for the next argument. Thank you.